Every legal system rests on a foundation. Without it, the courts have nothing to apply, and citizens have nothing binding their conduct. In Nigerian jurisprudence, that foundation is what scholars term the sources of law, the wellsprings from which legal rules derive both their substance and their validity. In the next few minutes, we examine the architecture of Nigerian law, where it comes from, how it is classified, and why some rules bind absolutely while others merely persuade. The jurist Salmond, in his seminal work on jurisprudence, identifies two broad categories of legal source: the formal or real source and the material source. A formal source is one that is binding in itself. It requires no further validation. Statutes and judicial precedent fall squarely within this category. They derive their force directly from the authority that created them. A material source, by contrast, supplies no immediately binding rule. It merely furnishes the raw material from which a rule of law may eventually be molded. Treaties, foreign case law, and historical antecedents fall into this category. They may inform the law, but they do not command obedience until formally received into the legal system. Within Nigerian jurisprudence, legal sources refer specifically to those sources recognized as such by the law itself. This category comprises legislation, or enacted law, case law, and customary law, although customary law's status as a primary source remains a subject of academic debate. For precedent to operate with any consistency, two structural conditions must exist: a hierarchical court system and a reliable mechanism of law reporting, so that past decisions may be studied and applied by subsequent courts. Nigerian law recognizes four principal or primary sources. First, received English law, which itself comprises three strands: the common law, the doctrines of equity, and statutes of general application that were in force in England as at the 1st of January, 1900. Second, Nigerian legislation law enacted directly by the national or state assemblies. Third, Nigerian case law, otherwise known as judicial precedent. And fourth, customary law, the body of indigenous rules recognized and enforced within particular communities. Each of these operates as an independent stream feeding into the broader river of Nigerian jurisprudence. In any functioning democracy, the legislature or parliament, or in Nigeria's case, the National Assembly, holds the constitutional authority to make law. Once a bill is passed through the prescribed procedure, it is presumed binding and enforceable upon the citizenry. But that authority is not absolute. The courts retain the power of constitutional review and may strike down a statute on any of three grounds. First, where a statute conflicts with any provision of the Constitution, the courts may declare it unconstitutional, pursuant to Section 1(3) of the 1999 Constitution of the Federal Republic of Nigeria, as amended. Second, where delegated or subsidiary legislation conflicts with its parent or enabling act, that subsidiary instrument may be declared null and void. Third, where a subsidiary statute is consistent with its enabling act, but nonetheless conflicts directly with the Constitution, it too will be struck down. This three-tiered safeguard entrenches the supremacy of the Constitution above every other instrument in the legal hierarchy. Statutes themselves fall into recognizable categories. A consolidated statute arises when a new act gathers existing statutory provisions on a common subject into a single instrument without altering the substance of the law, merely making it more accessible. A codifying statute, by contrast, reenacts the entirety of the existing law on a given branch, whether that law previously existed as precedent, statute, or a combination of both. Codification typically occurs only once an area of law has matured sufficiently. Premature codification risks both rigidity and stunted legal development. Not all law is made directly by Parliament. Delegated legislation refers to law made by a body other than the legislature, but under authority conferred by a parent or enabling act. Why does this matter? Several practical justifications support its existence. Parliament lacks the time to consider every regulatory detail. Delegated instruments permit a level of technical detail unsuited to primary legislation. Specialized bodies possess expertise and local knowledge that the legislature itself may not. Delegation also allows for broader consultation, and crucially, subsidiary instruments are far easier to amend than a full act of Parliament. Delegated legislation manifests in three principal forms: statutory instruments or regulations, exercised by ministers or departments; orders, typically reserved for matters of constitutional weight, such as emergency powers vested in a head of state; and by laws, made by local authorities under statutory authorization, subject to ministerial approval. Crucially, delegated power is not unchecked. Parliament retains parliamentary control, the authority to revoke or rescind delegated power, and most statutory instruments require parliamentary approval before taking effect. The judiciary, in turn, exercises judicial control. The courts may interrogate the validity of any delegated instrument and declare it void where it exceeds the authority granted, a doctrine known in law as ultra vires, meaning, literally, beyond the powers. Our final primary source is case law, frequently described as judge-made law. This characterization requires precision. Judges are not legislators, and the judiciary is not synonymous with the legislature. Rather, the phrase denotes that the principle laid down by a judge, in the course of resolving a dispute, becomes binding on courts of equal or subordinate rank. But not everything a judge utters in a judgment carries binding force. Only the ratio decidendi, the legal reasoning essential to the decision, is authoritative and binding. Any obiter dictum, a remark made in passing, not essential to the determination of the case, may be persuasive, but it is never binding. And unlike enacted law, case law cannot arise in a vacuum. It is forged exclusively through actual litigation. From the formal authority of statute, to the evolving wisdom of precedent, to the delegated instruments that fill in legislative gaps, the sources of Nigerian law form an interlocking structure, each strand reinforcing the supremacy of the Constitution at its apex. Understanding this architecture is the first step toward understanding Nigerian law itself. If this breakdown clarified the framework for you, subscribe for further explorations of Nigerian jurisprudence and drop a comment with the topic you'd like examined next.